Hello, everyone, and welcome to week 10. And in this module, we're going to be talking about the concept of loss distribution mechanisms. You would notice that because we're now in week 10, we're pretty close to the end of the term. And at this stage, I would imagine that you would know a lot about torts. We've in fact covered in the past 9 weeks the crucial principles of the torts. We've talked about torts based on negligence, or which often involve a breach of duty of care. We've also talked about intentional torts against a person, such as assault, battery, as well as false imprisonment. And then in the last week, we talked about nuisance. Now, in almost all of these cases of the different kinds of torts that were discussed, whether it was based on negligence or it was an intentional tort that was committed, or when we talked about nuisance, you would observe that in most of the cases, the liability was direct. So it was the tortfeasor who would end up becoming liable for the tort that was committed. However, if the law were to limit the liability, the imposition of liability on the tortfeasor himself, or the one who was directly responsible for the commission of the tort, whether because of negligence or because it was an intentional tort, there could be problems in the sense that the tortfeasor himself or herself may not have the money to be able to pay for the damage. And so what the law, the common law, as well as statutory law has done, is to find a way by which losses may actually be distributed. So for example, in this particular topic, we're going to be looking at the notion of vicarious liability, in the sense that there will be instances when somebody becomes liable for a tort, even though that particular person or individual or entity was not in fact responsible for the commission of the tort. We've talked, for example, in the past about employers having a duty of care towards their employees. And when an employee, for example, suffers an injury in the workplace, in that particular case, the employer has a direct liability for any commission of tort, in the sense that there was a breach of the duty of care and there was negligence in the workplace. So in that case, you would see that the liability of the employer would be direct as a result of the breach of the duty of care on the part of the employer. We will, however, often encounter instances where you might have an employee, for example, he might be a bus driver, and the bus driver may end up, for example, committing a negligent act and which causes huge losses to a number of persons when the bus crashes into another car, or may end up crashing into, for example, a gas station, which can lead to hundreds of thousands or millions of dollars in damages. Now, if we focus solely on direct liability, what the plaintiff would then do would be to seek to recover from the driver if it were the driver who were the cause of the injury. But in that scenario, how the driver will likely be unable to pay for the total cost or the total loss to a plaintiff, because as an employee, the employee certainly doesn't have the deep pockets that an employer normally has. Or you can have a scenario where you have you might have a production worker in a factory, and because of negligence, the worker in the factory may end up perhaps causing a fire in the building, burning the entire building, which may end up destroying some equipment, some machinery, which may belong to third parties. And then, there might be further losses down the line in the sense that there are other buildings that are burned. And again, if you base it solely on the principle of the tortfeasor being solely responsible for any loss or damage suffered by a plaintiff, then you will have a number of plaintiffs who will be unable to recover the payments, recover damages for the losses if they just are able to run after the employee who was responsible for the tort. So what has happened is that the law has provided a mechanism by which loss may be apportioned or may be distributed. And when we speak, for example, of the principle of vicarious liability, we notice that one of the reasons for the notion of vicarious liability is that in the context of in an employer and employee relationship, the notion is that even if it is an employee who is responsible for the tort, assuming that the employee was acting in the course of his employment, the employer will be vicariously liable for any damage or losses that is suffered by a plaintiff as a result of the actions of an employee. Even though we will notice in that notion of vicarious liability, even though there is in fact no fault on the part of an employer. So it is a form of loss distribution, as it is in the case, for example, of insurance, where motorists have their cars insured, so that even though they may suffer, they may cause damage or loss to a plaintiff or to another person, it will typically then be the insurance company which will bear the loss. So our focus today, or in this module, will be to talk about loss distribution mechanisms. So at the end of this module, you should be able to explain the concept of vicarious liability and discuss its theoretical basis, understand the difference between direct or primary liability and vicarious liability, describe the legal significance of a worker being classified as an employee or an independent contractor in relation to vicarious liability, apply relevant legal principles to fact scenarios to determine who is an employee, and then apply relevant legal principles to determine when a worker is said to be acting in the course of employment. We will, of course, be talking as well about the other loss distribution mechanisms, such as the proportionate liability, issues about proportionate liability, as well as the ability of tortfeasors to recover or to seek contribution from their co-tortfeasors. We'll also be looking at the principle of non-delegable duties. So as I already mentioned, besides insurance, there are other loss distribution mechanisms, which is a way by which the burden of compensating the plaintiff is shifted to another person, even though that person is not at fault. And the shift is because of the idea that another defendant may have deeper pockets than a defendant himself or herself who has been negligible. And so in this particular module, we'll be talking about vicarious liability. We're talking about the principle of non-delegable duty. We'll talk about contribution between tortfeasors, as well as the statutory schemes of proportionate liability for claims concerning economic loss or property damage. Now, before we talk about vicarious liability, let's do a quick review about the direct liability of the employer. So we know that where there is an employer and employee relationship, the employer then has a duty of care to ensure that there is no harm that will befall its employees. So for example, in Wilson's and Clyde Coal Company and English, it was clear in that particular case that employers have a duty of care to ensure that their plants and equipment are properly cared for and maintained, so that if there is a failure on the part of the employer to ensure that this happens, and there is injury or harm that is sustained by its employee, then the employer is liable. Now, in that scenario, the liability of the employer is direct or is primary, in the sense that it is understood that it is the employer who is at fault for failing to ensure that plant and equipment in which employees work, to ensure that these plants and equipment are properly maintained. In the case of Neil and New South Wales Fresh Food and Ice, the High Court said or emphasized that employers have a duty to provide a safe system of work, so that in the event that an employee has an accident in a workplace as a result of a failure of the employer to provide a safe system of work, even though it might be said that the employee was negligent, but that negligence was really because of a failure of an employer to provide a safe system of work. The employer will be held liable under the tort of negligence, but in that particular case, the liability of the employer is direct because it is in that scenario, it is the employer who had failed in its duty of care to prevent injury or harm to its employees. In the case of Butler and Fife Cole, in this scenario again, the court the Privy Council was clear that it is that as part of the duty of care of employers towards their employees, then they needed to make sure that they select individuals who are skilled and able to manage and superintend the business, so that if there is a failure on the part of certain workers, and then this leads again to harm to other workers, then the employer will be held to be directly and primarily liable for any damage or injury. So again, in all of these cases, and the cases we've mainly talked about in the past, the focus was on the direct and primary liability of the employer on the basis that the employer failed in its duty of care to ensure that workers or its employees are safe. Now, so when we talk about the direct liability of the employer, for example, in the context of negligence actions, there were three questions that essentially were asked. Did the employer have a duty of care? Did it breach its duty of care? And was the breach of the duty of care a necessary condition of the occurrence of the harm? Now, these types of questions we see when we talk about vicarious liability are not the same questions that we ask. And so we're going to be looking into that in a short while. So let's talk about the vicarious liability. So when a tort is committed by someone other than the defendant, for example, usually one of the defendant's employees, this may result in vicarious liability. So here we notice that the tort is committed not by the employer, but by somebody else, typically one of the employees of the defendant. And so therefore, when one of the employees of the defendant commits a tort, the tort that is committed by an employee of the defendant may lead to the employer having vicarious liability for that particular tort committed by the employee. So in that scenario, the employer itself was not responsible or did not even cause the harm, but because of the actions, the tortuous actions of one of its employees, the law will hold the employer vicariously liable for the tort committed by its employee. Now, the courts have struggled to identify a conceptual basis or a theoretical basis for holding the employer liable for a tort that it did not commit, but was in fact committed by one of its employees. One of this is based on what is known as the servant's tort theory, and the other one is known as the master's tort theory. Now, under the servant's tort theory, the explanation for the vicarious liability is that it is understood that the employer merely takes responsibility for a tort committed by the employee. So that when, under the servant's tort theory, therefore, any actions committed or any tort committed by an employee is considered to be the responsibility of the employer himself. And because the employer is responsible for the actions of the employee, when an employee commits a tort, then the employer has to be held liable, vicariously liable. So that is one of the theoretical bases there. The other theoretical basis would be to think that the employee's actions are attributed to the employer, so that when the tort is committed by the employee, it is as if it is the employer himself or herself that committed the tort. So in other words, the tort is not the tort committed by the servant, but a tort committed by the master or the employer, even though in truth, it is the employee that was responsible for the commission of the tort. Now, of course, it's not just in the context of the employer-employee relationship that you can have vicarious liability for tortuous actions. You can also have situations where the principal may be held liable for the tortuous actions of his agent. And this assumes that when we speak of an agency, this is an actual agency under the law. So For example, in the case of Colonial Mutual Life Assurance Society Limited and Producers and Citizens Cooperative Assurance Company of Australia Limited, the High Court clarified that the relationship of principal and agent gives rise to vicarious liability on the part of the principal for the torts that are committed by the agent. And again, I mentioned that it is important that when you speak of the agent in this concept, in the context of principal and agent, it is understood that we're dealing with an individual, an agent in law, in the sense that the agent is in fact has the legal authority to act for and on behalf of the principal to such an extent that the agent is even able to bind the principal. Now, this is different in the context of, you might have a company that hires a so-called agent to sell its products, to market its goods and so on. In that particular scenario, that agent or the sales agent is not in fact an agent as we understand in the context of the principal and agent relationship, or what is known as agency in law. Because when you speak of actual legal agency, the agent must be able to typically bind and represent the principal. So in a principal and agent where there's a relationship of principal and agent, so that the agent is almost the alter ego of the principal, then any tortious actions committed by the agent will mean that the principal will then be vicariously liable for any damage that is, or injury that is sustained by a plaintiff. We will also see that other instances of vicarious liability may involve a hospital, and it can have vicarious liability to workers working in the hospital if they commit harm to patients. You can also have a situation where there might be vicarious liability on the part of the school, again, for actions that happen in relation to students. So, but the most common form of the most common instance when there is vicarious liability usually relates to when there is an employer and employee relationship. Now, in order to be able to establish that there is vicarious liability on the part of the employer, there are two main questions that are asked. And as I mentioned, these questions are distinct from the questions we asked earlier about when an employer would have direct liability for tortious action. So in relation to vicarious liability, there are two questions. Was the tortfeasor the defendant's employee at all? And two, was the tortfeasor acting in the course of his or her employment at the time that the tort was committed? We notice, therefore, with these two questions, there is no scope or room on the part of the employer to assert that it did not breach its duty of care. Okay, the moment a defendant's employee commits a negligent act or an intentional act that leads to damage, that commits tort that leads to damage to a plaintiff, the employer cannot forward a defense that it did not breach its duty of care, for example, in terms of hiring the employee. There is that is not a defense, because it's the principle of vicarious liability, especially in relation to employer and employee relationships, is that this is a strict liability on the part of the employer. So there are only two questions that need to be asked. Was the tortfeasor the defendant's employee at all? And so therefore we ask that question in the context of was the worker actually an employee, or was the worker an independent contractor? We're going to be examining that. And then the second question is, assuming that the tortfeasor was in fact an employee, was he or she acting in the course of his or her employment at the time that the tort was committed? Now, this second question, when we go through this module, is also a bit complex, because you might have a scenario where you can have a bouncer, and it is the job of the bouncer in a bar, for example, to ensure that there is peace and order inside the bar, that if there's disorderly behavior, he ensures that there no other patrons in the bar will be harmed. But what if in the process the bouncer becomes angry and he ends up beating one of the patrons. The question then is, would the bar in which the bouncer was employed, and the bouncer then ended up beating up a patron, would the bar be held vicariously liable for the injury to the patron? Now, that question is, was the bouncer acting the course of his employment in beating up a patron? And certainly it could be argued that it certainly isn't within the scope of the job of the bouncer to be beating up patrons, right? So in that case, is the bar vicariously liable? We're going to be examining that question in a short while. So keep that in mind. You may also have a situation where part of the work instructions might be clear. Workers, employees shouldn't be smoking in a particular place of the factory. And yet, what if in contravention of that particular policy, one or two of the employees' workers end up smoking, and as a result of them smoking, they may end up throwing the cigarette butts, or there might be certain flammable materials which end up leading to the entire building, catching fire, which then cause damage and fire to other adjoining buildings. In that case, could it be considered that the smoking by the employees who committed the tort, in violation of clear policies of the employer, could that be considered to be actions of the employees in the course of their employment? You may have a situation as well where you have school teachers, so let's say in elementary school or in high school, where the teachers may end up committing sexual crimes against their students. Now, certainly, it isn't part of the employment of teachers to be committing sexual assault against students. But the question then would be, would the school be held vicariously liable for the sexual assault committed by their teachers? You may also have a situation where you may have a financial investment company, and you have financial advisors who commit crimes. They commit fraud, and in doing so, they end up at some point, facing criminal matters and potentially even being convicted for fraud. But in the process, the fraud could have led to financial damage and harm to their clients. Now, the criminal actions of the employees of that financial company. So what did I say? So would the employer be vicariously liable for the actions of the employees when these actions were in fact criminal in nature, and therefore arguably not part of the employment or scope of work of the employees? So these are some of the questions we're examining when we look at vicarious liability, and then later on we talk about non-delegable duties. So as a general rule, the employer will have vicarious liability for employees, but not for independent contractors. It's crucial for us to get a sense of, when is there an employer-employee relationship? Now, we need to be clear that this is not a unit on employment law. And in fact, it might be possible that an individual may be considered an employee in relation to a tortious action, but not an employee based on employment law. So let's be clear about that. And so therefore, when we speak of the employer-employee relationship here, we're dealing with this concept solely in relation to the law on torts. And our goal is to just get a good sense about when is somebody or a worker considered an employee and therefore part of an employer-employee relationship under the tort tort law. So, for example, if you were to hire a taxi driver or an Uber driver, even if the taxi driver or Uber driver, picks you up regularly and drives you home regularly, that taxi driver, Uber driver does not become your employee simply because you pay him or her to drive you home or to work. That taxi driver, Uber driver would still be described as an independent contractor. Now, however, if you actually have a chauffeur to drive you around at all times, to bring you to different places, and in all likelihood, that particular chauffeur only works for you for clear periods of time, then that particular chauffeur is likely to be considered an employee. In which case, therefore, that any tortious actions committed by that chauffeur and acting in the course of his employment would mean that it will also lead to vicarious liability on your part. So here, in relation to the chauffeur who would be considered an employee, you would be vicariously liable for torts that he commits, but not in relation to a taxi driver or an Uber driver. Now, so what have been the tests that, what tests have been used by the courts to determine whether or not there is an employer-employee relationship? One of the tests that often has been used by the courts to determine whether or not there's an employer-employee relationship involves the employer's right to control the employee's work. So for example, in a contract of service, so when you contract somebody for his services, there usually exists an employer-employee relationship if the employer controls what work was done and how work was done. So if you're able to determine, the particular work that a worker ought to be doing and how that work ought to be done, so there's a high level of control on the part of the employer, then that in that scenario, that contract of service will be considered or classified as bearing the indicators of an employer-employee relationship, which would then mean that the employer can be held vicariously liable for any torts that are committed by that employee. The control test, when you think about it, works well when you deal with unskilled employees, because when it comes to unskilled employees, the employer often really tells the employer what ought to be done and how it should be done. But can that really be said in relation to highly skilled employees, such as lawyers, research scientists, maybe even academics, for example? Can it really be said that the employer exercises control over them, over highly skilled employees? For example, in relation to academics, the university or the dean doesn't really engage with academics. The only time that we engage with each other will probably be in meetings, which can be once every 2 weeks. And even then, these are short meetings. But other than that, academics do things on their own. But are we, in fact, considered employees? So if you follow the control test, it will be very difficult to say what work is done and how work is done, because to a great extent, academics determine what work needs to be done. And remember, when you speak of work, for example, the work of an academic doesn't just involve teaching. It can involve research. It can also involve supervising research high degree students. It can involve trying to seek research grants and so on. And no one tells an academic as to what should be done, what the focus should be, and how they should be done, especially when it comes to research. So the control test, if you rely solely on the control test, it becomes problematic. But there is no question that a lot of the academics, in fact, are considered employees. In my case, I am an employee, for example, of Central Queensland University. So the test has often been modified so that in the case of Stevens and Broadrib Sawmilling Company Proprietary Limited, the High Court said that the ultimate question will always be whether a person is acting as the servant of another or on his own behalf. And the answer to that question may be indicated in ways which are not always the same and which do not always have the same significance. Now, in my case, it's pretty clear that I am an employee because I act, well, as a servant of the university. So the university gives me broad guidelines, and I can only work for them and focus on particular goals. I don't act on my behalf, unlike an independent contractor. So that is one of the ways by which the control test has been modified. The other way of looking at it is the integration or enterprise test. For example, when you look at the case of Hollis versus Vabu Proprietary Limited, the plaintiff had filed an action for tort also against a company, and it was claimed that the bicycle courier was an employee of the company. The bicycle courier had been negligent in the way that he drove on the pavement. The bicycle courier couldn't even be identified in the sense of who he was, but the plaintiff could identify the bicycle courier as belonging to the company because of the uniform that the bicycle courier was wearing. Now the question was that bicycle courier considered an employee of the company? The company was claiming that the courier was not at its employees because it really didn't have any control over the bicycle courier. There might even have been a contract which said that the bicycle courier was not an employee, but was in fact an independent contractor. But here, the court said that the better test that should be used, the High Court said that the better test that should be used is in fact the integration or enterprise test, which means that where the employer's enterprise has created the risk that produced the Tortious Act, the employer must bear responsibility for it. So viewed as a practical matter, the bicycle couriers were not running their own business or enterprise, nor did they have independence in the conduct of their independent operations. So a different conclusion might, for example, be appropriate, where the investment in capital equipment was more significant and greater scale and training were required to operate it. So today, we often come across a lot of couriers who drive their own vans. You might even have instances where you might have plumbers and electricians driving their own vans, but working for a company. The question is, are these workers driving their own vans considered employees of the company, or are they independent contractors? Again, if you use the control test, there might be constraints to the control test because it might be argued that to a great extent, a company really doesn't exert much control in terms of what work needs to be done or how work ought to be done. So, but then if you apply the integration or enterprise test, the basic question that really becomes that then is asked is whether or not it is the employer's enterprise that has created the risk that might produce a tortious act. And then you weigh this against issues about investment in capital equipment on the part of the worker. But as we can see, the line can sometimes be difficult to draw. It hasn't stopped the courts apparently from determining whether or not there in fact is an employer or employee relationship using different tests for that purpose. So we have already talked about the employer-employee relationship. So the first question we asked was the tortfeasor an employee of the employer? So in that case, we looked at various tests to determine whether or not a worker should be considered an employee of the employer. But the second question, remember, we need to ask is, assuming that the assuming that a worker who committed the tort is an employee of the employer, was that employee acting in the course of employment? Because if he was, then there would be vicarious liability on the part of the employer. But if he was not, there wouldn't be any vicarious liability. So the rule is that an employer is not vicariously liable for all the torts committed by her or his employees, but only those that are committed in the course of the employee's employment. So that the employer is not vicariously liable for torts committed by the employee while on a frolic of his own. Now, we will examine instances where an employee may be performing a particular task that is not according to what the employer said, and yet that will be caught in the idea that the activities or the actions of the employee were still part of the course of employment. So an employee who is employed to perform a particular task or tasks may still be acting within the scope of her or his employment, even when not performing those tasks. So in the case of Century Insurance Company Limited versus Northern Ireland Transport Board, what had happened here was that an employee, was responsible, was driving a fuel tank, one of those huge tankers that, would go around filling up fuel in various gas stations or fuel stations. And apparently, as we would expect, it would be prohibited on the part of the driver to be smoking. But here, the employee lit a match, and which caused an explosion and fire that burned the filling station. And certainly, the argument on the part of the company or the employer was that the employee was not employed to smoke cigarettes and not employed to strike matches. Therefore, those specific acts that led to the fire and the explosion at the filling station couldn't be attributed to the employer. So, but the court said that although the employee's duty was to watch over the delivery of the spirit into the tank, so he was close to the apparatus, his negligence in starting smoking and in throwing a lighted match at that moment is plainly negligence, but it was still in the discharge of his duties. So all these acts of, probably putting in the fuel hose into whatever reservoir there was, that was part of the discharge of the duties. Now, when he was discharging the duty and he lit a match, that was a negligent discharge of duty, but still part of the discharge of duty. So in that case, the court said that the employer would be held vicariously liable for the actions of the employee because the employee in that instance was still acting within the course of his employment. The scope of an employee's employment also includes those acts that he or she is authorized to perform, as well as the tasks that she is specifically required to perform. In the case of Bog versus Brown, the farmhand, who was an employee of the employer, was permitted to cook meat on a part of the defendant's land, and this was meant to be at a hut that was supplied by the defendant company, by the defendant employer, on his own land. What the farmhand did in cooking the meat was that he did it in a different part of the defendant's land, in violation of the clear instructions of the employer. But this act led to a fire that then burned the plaintiff's property. The question was, can the employer be held liable for the actions of the employee, noting that the employee had clearly violated the specific instructions of the employer? And the answer is yes. So here the court said that the precise terms of the authority are not the criterion of liability. The function, the operation, the class of act to be done by the employee is the criterion, whatever it be the instructions as to the time, the place, or the manner of doing the act. In other words, the employer is liable for damage resulting from the negligent use of a fire on his land if he has sanctioned the lighting of a fire anywhere on his property for the occasion. In Didon's Propriety Limited versus Flu, though, the question was, you have a barmaid, who became angry after arguing with one of the customers or patrons. She threw a glass of beer into a customer's face, which led to one of his eyes being blind. Was that acting in the course of employment? Remember, again, you have a scenario that one of the questions I earlier asked was, you have a bouncer who ends up fighting with, or who ends up beating one of the patrons at a bar. Is that acting in the course of employment? But here, the defendant hotel was not held vicariously liable for the barmaid's act. And the High Court said that it is not suggested that the barmaid was employed to throw beer in the customers' faces, but it is contended that the throwing of the beer was incidental to her employment as a barmaid, in that she was placed in the bar to deal with customers and to answer such questions as customers might naturally ask. In my opinion, the act of the barmaid was not so connected with any authorized act as to be a mode of doing it, but was an independent personal act which was not connected with or incidental in any manner to the work which the barmaid was employed to perform, according to Chief Justice Latham. In the scenario I gave about a bouncer beating up a patron, it is likely the case that if the bouncer ended up beating a patron, that action would be considered as falling within the scope of the work of the bouncer, even if it will be in violation of the policy of the bar. And for that reason, that would lead to vicarious liability on the part of the employer, of the bouncer. That's a different scenario that I mentioned. In the case of Phoenix Society Incorporated versus Kavanaugh, this was another case where the employee has performed a task so differently from what she was employed or authorized. And you could really argue that the mode was unauthorized, but this could be, the question was, could this be regarded as an unauthorized mode of performing an authorized task? So here, the driver was employed by the defendant to drive one of its buses. She was driving as part of her employment when this accident occurred. The fact that she was driving with such a high blood alcohol count and contrary to instructions of the employer does not alter the fact that she was doing what she had been employed to do, namely drive the bus on this occasion. And for that reason, the defendant company was held vicariously liable. Now, so we've talked about the actions of employees which diverged from the usual scope and nature of work of an employee, but they were essentially civil in nature. The question is, what happens when the conduct or actions of an employee actually amount to a serious criminal offense? Would that still be acting in the course of employment? So the examples I gave was that, you can have a financial advisor who commits fraud, criminal fraud, defrauding a lot of clients, which lead to financial losses on the part of the clients. Certainly, the employer couldn't have sanctioned. Let's assume that the employer did not sanction, the criminal behavior. Would the employer still be held liable? One of the interesting historical incidents we have occurred it did occur in 1995, but it ended in 1995 with the demise of the Barings Bank, one of the oldest banking institutions in the UK. It was worth more than several billions of dollars. But eventually, Barings Bank shut down in 1995 as a result of criminal behavior by one of the investment bankers known as Nick Leeson, who was based in Singapore, involved in derivative trading, and he ended up doing a lot of very risky speculative trades, and which led to initially millions of losses. And in order to cover his tracks, to ensure that no one knew about the losses, he fraudulently changed a lot of the financial records. Eventually, when it was discovered, it was too late, and the company closed down. In that scenario, Nick Leeson eventually was jailed, I think, for close to 20 years. And the question is, given that the actions of Nick Leeson, or in a situation where you have an employee who is acting really contrary to policies of the company, and these actions in fact amount to serious criminal offense, could it be said that the employee was still acting in the course of employment, such as teachers ending up committing sexual assault against their students? So in the case of New South Wales versus Lepore, Samin versus Queensland, Rich versus Queensland, these cases, which were consolidated in the High Court, involved school students who filed suit against the school after they had been sexually abused by their teachers. The schools were held vicariously liable by the High Court. And the High Court said that when an employer is alleged to be vicariously liable for the intentional tort of an employee, recovery against the employer on that basis may still proceed. First, where the conduct of which complaint is made was done in the intended pursuit of the employer's interests or in the intended performance of the contract of employment, or secondly, where the conduct of which complaint is made was done in the ostensible pursuit of the employer's business or the apparent execution of the authority which the employer held out of the employee as having. So in these cases, for example, although it couldn't be said, well, it certainly couldn't be said that the sexual assault or the sexual abuse was really part of the scope of the duties of the teachers. But were it not for the position of authority and responsibility of the teachers, then none of the sexual abuse or sexual assault would have happened. And so it could clearly then be said that even though these actions were criminal in nature, they were actions within the scope of the employment of the teachers, and therefore the school was held vicariously liable. In the case of Prince Alfred College Inc. versus ADC, the plaintiff was sexually assaulted by a school boarding house in 1962, and we'll look at the limitation of actions in a short while. Was the school vicariously liable? So the High Court said that the fact that the wrongful act is a criminal offense does not preclude a finding of vicarious liability, so that should be clear. There's a need to determine whether the employer gave the employee a special role whereby its performance gave occasion to the wrongful act. Now, if the employee takes advantage of his position in relation to the victim, this may then be within the scope of the employment, and thereby the employer is vicariously liable. The fact that a wrongful act is a criminal offense does not preclude a finding of vicarious liability. Hang on, that's repetitive there. Okay. Now, however, in this particular case, the action was dismissed because of the limitation period which had lapsed. So here, the High Court refused to allow an extension of the limitation period. There must be strong reasons, according to the court, for allowing proceedings to be brought against a defendant where they may have been led to believe by the plaintiff that no future action would be taken. So here, there had been an initial settlement on the part of the plaintiff and the defendant, including allowing the plaintiff's son to go to school in that particular college. And then at some point, the plaintiff changed his mind, so many years after, by which time the action had prescribed. And here, the High Court refused to allow an extension of the limitation period. And yet, but in relation to the issue of vicarious liability, the High Court would have made a finding that the school could have been vicariously liable for the tortious actions involving sexual assault committed by the teachers of the college. There have also been Australian cases applying principles in Lepore's case. Remember the New South Wales versus Lepore involving students who were sexually abused by their teachers. And the focus has been on the nature of the tasks that the employee was authorized to perform. So in the case of Ryan versus Ann Street Holdings Proprietary Limited, the nightclub was vicariously liable for the bouncer's action. So the critical test involves a comparison between the intentional wrongful conduct and the type of conduct the employee was engaged to perform. So if there is a sufficient connection or a sufficiently close connection or a close connection between the actual work of the bouncer and the tortious action, it will be open to the tribunal of fact to conclude that the wrongful act was done in the course of employment, albeit in an improper mode. In French versus Sestili, the carer was employed by the defendant company to take care of an injured woman. But what the carer did in breach of trust was to steal the money from the injured woman who was under her care. The court held the defendant company vicariously liable. Again, it wasn't the defendant company that stole the money. It was one of its carers, and certainly the carer was never instructed to steal money. But the court vicariously held the defendant company So the reason was that the unauthorized withdrawals were so closely connected to the authorized withdrawals that there were improper modes of discharging the duty to withdraw money, a task which had been instructed. Her wrongful acts were sufficiently related to the conduct authorized as to justify the imposition of vicarious liability. In the case of Atanaskovich, the issue was Clark, the solicitor, acting in the course of employment as a solicitor when he defrauded the plaintiff of millions of dollars. And it was held that, yes, he was. Clark was acting in the course of his employment with the defendant when he defrauded the plaintiff. So the frauds were made possible because of Clark's position as a trusted solicitor working for a law firm for a long-standing and valuable client. Clark had an involvement to the knowledge of those at the defendant law firm in each matter, which transpired to be the particular vehicle for each fraud. It is somewhat difficult to see how it could be said that Clark's employment did not give him the opportunity for and was not the occasion for the frauds. Now, so we've covered that. We said that when we tried to examine the vicarious liability employer, we asked two questions. Was the worker, in fact, an employee of the defendant company? And two, was the employee acting in the course of his employment? Now, assuming that there is a finding of vicarious liability, the question is, can the employer run after the employee for contribution? The other question might be that, oftentimes employers take up insurance to indemnify them for any losses as a result of tortious actions of their employees. The question is, can an insurance company seek contribution from the employees on behalf of the company? So we're going to be examining that in these particular sections. So in law, under the common law, if a plaintiff sues an employer who is held to be vicariously liable, the employer may then sue the wrongdoing employee to recover an indemnity for the sums the employer has had to pay the plaintiff. And that is so because there is an implied term in the contract of employment to the effect that the employee will not perform his or her duties in such a way as to cause the employer to be held vicariously liable. Now, however, in New South Wales, South Australia, and the Northern Territory, the employer's right of indemnity has been abolished by legislation. So the employer's right to contribution or indemnity against an employee has been abolished. It's no longer permitted under statute in New South Wales, South Australia, and the Northern Territory. You can imagine a scenario where because of the negligence of an employee, it leads to millions of dollars of damages. And can you imagine if the employer then runs after the employee for contribution or indemnity? That will certainly lead to financial ruin. And the question is, who is in a better position anyway to bear the loss? Who has deeper pockets? So in New South Wales and South Australia and the Northern Territory, but not in Queensland, the employer's right of indemnity has been abolished by legislation, except where the employee is guilty of serious and willful misconduct. Now, in relation to the right of an insurer to enforce the employer's right of the indemnity, this too has been abolished throughout Australia by the Insurance Contracts Act of 1964, unless under Section 66B, the employee is guilty of serious or willful misconduct. So as a general rule, the insuring company cannot seek indemnity against an employee where the employer has been held vicariously liable. Okay, so we've now covered, that's a long time, almost an hour. So we've now covered that part about the loss, vicarious liability as a loss distribution mechanism. Let's now talk about non-delegable duties. So the idea here about non-delegable duties is that there are certain duties that an employer cannot delegate even to an independent contractor. Okay, so remember we initially said that if an independent contractor commits tortious actions, then the employer cannot be held liable. It is only when there's an employer-employee relationship. So if there's an independent contractor commits, burns a building and so on in general, the employer cannot be held liable because there is no employer-employee relationship. However, there are certain non-delegable duties, as I mentioned, so that In general, a defendant is not vicariously liable for torts committed by an independent contractor, but the defendant company may be directly liable to a plaintiff who is injured as a result of what the independent contractor has done. In those cases, the defendant is held to be liable for breach of his or her own non-delegable duty. So there are certain duties that cannot be delegated, as we shall see. In the case of Condis and State Transport Authority, the plaintiff employee had been injured when a crane jib that was operated by an independent contractor and hired by the defendant fell on him. So notice that it was the independent contractor that caused the injury to the plaintiff's employee. It wasn't the employer, it was an independent contractor. So if you follow the common law, then the employer cannot be held liable for the injury to the employee, especially where there is no proof that there was a breach of duty of care on the part of the employer. Here, the High Court mentioned, several classes of cases where which give rise to a non-delegable duty. This can be in relation to hospitals and patients and schools and principals. So the High Court said, speaking through Chief Justice Mason, that in these situations, the special duty arises because the person on whom it is imposed has undertaken the care, supervision, or control of the person or property of another, or is so placed in relation to the person or property as to assume a particular responsibility for his or its safety. In this case, in the case of the employer, there is no unfairness in imposing on him a non-delegable duty. It is reasonable that he should bear liability for the negligence of his independent contractors in devising a safe system of work. So ultimately, therefore, when it comes to a safe system of work, the employer can just say, oh, I am not responsible for that. I've delegated that responsibility to an independent contractor. That argument will not be allowed. There will be instances where there are certain non-delegable duties that are expected on the part of the employer. And so these kinds of duties cannot be contracted out. We need to be clear, though, that the distinction between employees and independent contractors continues to be important, especially in the context of vicarious liability. In the case of Layton Contractors Proprietary Limited versus Fox, this is again a complicated case because the defendant was a principal contractor for a building project. And as we know, principal contractors of building projects typically subcontract them. The subcontractor subcontracts it to another one. So you might have a company that is responsible for building an entire building. There will be independent contractors for concreting, independent contractors for lighting, independent contractors for sewerage, and so on. And these independent contractors will then farm out again and subcontract some of the work. And here in Layton Contractors Proprietary Limited versus Fox, the defendant was a principal contractor for the building project, which subcontracted with Downview, which subcontracted Still and Cook, who then engaged two of their employees, including the plaintiff, to work at a project site. The plaintiff was injured and the plaintiff, was an employee of Still and Cook. The plaintiff was injured when Still and Stewart, how did that become Cook? Was that Still and Cook? There was a co-worker who was also an employee when Still and Stewart negligently swung a concrete delivery pipe. And the High Court said that the Layton Contractors was held liable anyway. So a duty to provide training in the safe method of carrying out the contractor's specialized task is inconsistent with the maintenance of the distinction between the obligation employers of their employees and of principals to independent contractors. So even though the plaintiff was not an employee of the defendant Layton Contractors Company, hang on. Yeah. So it was emphasized here that Layton Contractors, in fact, was not the defendant company was not considered liable here. This was different because it could be understood that the defendant subcontractors were in a better position to determine, the safety methods and so on. so that the distinction between employees and independent contractors continues to be important. In the case of Bernie Port Authority and General Jones Proprietary Limited, there was a fire on the premises that was occupied by the defendant. So here, the negligence was started by the independent contractor, which carried out welding works near highly flammable material. In this case, the defendant company was still held liable for the fire, even though it was the independent contractor that had been responsible for it. And the High Court said that the relationship of proximity giving rise to the non-delegable duty of care is marked by special dependence or vulnerability. One party to that relationship is a person who is in control of the premises and who has taken advantage of that control. The other party is a person outside the premises and without control, specially dependent upon the person in control to ensure that such reasonable precautions are taken. The duty in that category of case is a non-delegable one. So here, the plaintiff, whose premises were burned, were really dependent on the defendant company ensuring that whatever activities were undertaken in its premises, even by an independent contractor, were safe. And so that duty to ensure that the defendant company, takes reasonable precautions to ensure that there is no harm that befalls its adjoining neighbors, is a duty that is non-delegable. So here, the defendant company was held liable even though the injury was caused by an independent contractor. In that particular case, the High Court said that even where a dangerous substance or a dangerous activity is involved, the standard of care remains that which is reasonable in the circumstances, that which a reasonably prudent man would exercise in the circumstances. In the case of such substances or activities, however, a reasonably prudent person would exercise a higher degree of care. Indeed, depending upon the magnitude of the danger, the standard of reasonable care may involve a degree of diligence so stringent as to amount to practically to a guarantee of safety. So we've talked about vicarious liability. We've also talked about non-delegable duties. A third loss distribution mechanism is the right of a tortfeasor to seek contribution from other tortfeasors. So that if the defendant can prove that another tortfeasor was partly to blame for the plaintiff's injury, the amount that the defendant has to pay may be reduced. So a co-tortfeasor may seek contribution from the other tortfeasors. Now, in relation to a personal injury case, there is a requirement that in order for a defendant tortfeasor to seek contribution from the other tortfeasors, the defendant must bring an action, either a cross-claim or a third-party notice against other tortfeasors seeking contribution from them. So there has to be a separate action, either a cross-claim or a third-party notice. In some jurisdictions, a third-party notice is considered to be part of a cross-claim. We're not going to get into the civil procedure here, though, but essentially, in some jurisdictions, a cross-claim is a claim that is made against a co-defendant, but it can also be a claim against a third party. So if it's a personal injury case, the only way that a co-defendant is able to seek contribution from a co-tortfeasor would be to bring a separate action, either a cross-claim or a third-party notice. But in other kinds of losses, there is statutory scheme in each jurisdiction which entitles the defendant to reduce liability by proving that other tortfeasors were partly to blame for the harm suffered by the plaintiff. So there is, in relation to other kinds of laws, there is no need for a defendant tortfeasor to file a cross-claim or make a third-party claim. Now, this is another crucial point. At common law, the plaintiff, assuming that there are several tortfeasors, the plaintiff can recover damages in full from any of the tortfeasors based on the principle of joint and several liability or solidary liability. So even if there are many tortfeasors who were responsible for the damage that was suffered by a plaintiff, the plaintiff can recover damages in full from any of them. So even if there were 10 of them, all of the 10 are considered joint and severally liable, or they have solidary liability. And as a result, the plaintiff can seek damages from even just one of them, because the understanding is he can recover damages in full from any of the tortfeasors under the principle of joint and several liability or solidary liability. In which case, if there is a judgment against all the defendants with solidary liability, they can be enforced against any of them. So again, if there were a finding of solidary liability against many defendant co-tortfeasors, the plaintiff can choose whoever has the bigger pocket in terms of seeking enforcement of the judgment, which might mean that, out of 5 co-tortfeasors, there will only be one who will end up, paying for the full amount. Okay, but we're going to look at the issue about seeking contribution later on. Now, the thing was, under the common law, in the case of Merriweather versus Nixon, the defendant then had no right to recover a contribution from other co-tortfeasors under the no contribution law rule, so that the defendant that was chosen by the plaintiff to pay for the damages ended up bearing the whole loss, even if it was only partly to blame. So in a sense, you might say that it's pretty unfair, right? So the no contribution rule in Merriweather has been replaced by legislation in each Australian jurisdiction, for example, under the Law Reform Act of 1995, Queensland Section 6, so that, it's not possible, therefore, for a tortfeasor to seek contribution from other co-tortfeasors. But the common law system of joint and several liability still remains. So because of the joint and several liability, it's still possible for a plaintiff to seek damages against just one tortfeasor among many. And it will now be the problem of that particular tortfeasor to seek contribution from the others. So the legislation will apply both to concurrent tortfeasors. This involves people who have committed different torts leading to the same harm, as well as to joint tortfeasors, people who have combined to cause the same harm by committing the same kind of tort. So what's the difference between the two? When you look at New South Wales versus Taylor, for example, a claim brought by sexual assault victims of a former state employee, what occurred would be considered to be concurrent tortfeasors. One of the tortfeasors would, of course, be the person who committed the sexual assault, the employee of New South Wales. So the tort there was the sexual assault. But New South Wales itself was also considered a tortfeasor because it had failed to prevent one of its employees from committing the sexual assault. So these are two different torts which led to the same harm, but they are considered concurrent tortfeasors. You might have a scenario as well, as we see in one case where there are various torts that have been committed which end up leading the same harm. It might mean that one is committing fraud, another one might be doing something else, but they all lead to the same harm, even though there might be different torts involved. That would be concurrent tort. So a plaintiff is injured by the negligence of two or more tortfeasors still has a choice to sue all of the tortfeasors as defendants or sue only one of the tortfeasors. Now, the chosen defendant would then be able to would then seek to recover contribution from other tortfeasors. So, in a sense, it's almost anomalous. Some academics have argued that situation is anomalous, where the plaintiff is able to only pursue or sue one of the tortfeasors, and then leave it to that tortfeasor to then seek contribution from other co-tortfeasors. To them, the plaintiff should have impleaded all the tortfeasors as co-defendants. So, in relation to the rules of joint and several liability, there's always a risk of insolvency or disappearance of other tortfeasors, so that it falls on the solvent defendant. So that even if there might be solidary liability. If there is solidary liability on the part of all the co-tortfeasors, it is possible that some of these co-tortfeasors may end up becoming insolvent, or they may disappear, they couldn't be found, in which case it becomes the solvent defendant, the solvent defendant, who ends up bearing the whole burden of the damage. But that's still the case. Now, in all Australian jurisdictions, there is, however, a system of proportionate liability for claims concerning economic loss or property damage. So it's only in relation to economic loss or property damage where there is a system of proportionate liability. In the case of personal injury, this does not exist. Okay, so but what is the system of proportionate liability? Under the system, the tortfeasor cannot be held liable for more than her or his proportionate share of responsibility. The plaintiff must sue all the tortfeasors to recover the appropriate share of damages from each, and the plaintiff shares in the risk of insolvency or disappearance. And so therefore the concepts of apportionable claim and concurrent wrongdoer are central to the statutory scheme of proportionate liability. So for example, under the Civil Liability Act 2003, Queensland, section 30, subparagraph 1, a concurrent wrongdoer is defined in relation to a claim as a person is one of two or more persons whose acts or omissions caused, independently of each other, the loss or damage that is subject of the claim. So in relation to claims concerning economic loss or property damage, it's possible to have a system of proportionate liability. But when it comes to personal injury, there is no claim of, various tortfeasors cannot claim proportionate liability. What will then happen is that there will be solidary joint and several liability or solidary liability of all the tortfeasors for the full value of the damages that have been awarded by a court. In the case of Hunt and Hunt Lawyers versus Mitchell Morgan Nominees Proprietary Limited, this demonstrates how proportionate liability works. This involves an economic loss. The defendant was a firm of solicitors. There were concurrent wrongdoers with others. So what had happened was the initial fraud had been committed by a co-defendant when he fraudulently claimed that certain titles to lots could be mortgaged by him, and that the plaintiff had authorized this. And so there was a fraud there. Now, in order for this fraud to be successful, one of the co-defendants then engaged a solicitor cousin to assist in the preparation of fraudulent documents, and there were issues about whether or not the mortgage was in relation to a particular sum or for the entire loan. Now, but the High Court ruled that the liability of the defendant firm could not exceed 12.5%. So that because the plaintiff's inability to enforce the mortgage over property because of fraud was directly caused by the defendant's negligent drafting of the mortgage document. So in other words, if there was any liability on the part of the defendant firm, it was in a failure to properly draft the mortgage document. So the part of the risk of unrecoverable loss should be shifted to the plaintiff. And this was in relation to the fraud that was committed in order to be able to get the loan. And that was not committed by the lawyers, but committed by a co-defendant, so that the fraudulent wrongdoers remained jointly and severally liable for the economic loss or property damage, but they were insolvent. Okay, so at the end of this module, you should be able to explain the concept of vicarious liability and discuss its theoretical basis, understand the difference between direct or primary liability and vicarious liability, describe the legal significance of a worker being classified as an employee or independent contractor in relation to vicarious liability, apply relevant legal principles to fact scenarios to determine who is an employee, and apply relevant legal principles to determine when a worker is said to be acting in the course of employment. And of course, we also talked about non-delegable duties. We also talked about contribution, seeking contribution, from co-tortious, and we also talked about proportionate liability as the other loss distribution mechanisms. And with that, thanks for watching this video. Bye.